Hi, everybody. I'm Diane Brady. The Supreme Court recently made a decision to pause the deal that Purdue struck in bankruptcy court that would have involved basically resolving the Sackler's claims over opioid abuse. That's OxyContin. And there are a lot of similarities with other cases out there, most notably Johnson & Johnson and the talc case related to cancer. With me is Jon Ruckdeschel. Jon, I hope I got that correct in terms of my expression of what's going on. You are one of the trial lawyers who moved to dismiss these cases from bankruptcy court. Let's first start with where the similarities lie between these two cases.
The key similarity here with Johnson & Johnson's attempt to manipulate the bankruptcy system and the Sacklers is the fundamental point that they're trying to use the bankruptcy courts to get bankruptcy relief without actually filing for bankruptcy, and it's subjecting themselves to the oversight of the court. So the Sacklers individually and Johnson & Johnson, the corporate parent that also used to run the talc business, are identically situated in the way they're trying to manipulate the bankruptcy courts and the bankruptcy system to essentially avoid scrutiny from the courts and from the claimants that they've harmed.
Let me, the Texas two-step, this is in essence, let's describe what that is, because this is not something that is unique to Johnson & Johnson or to Purdue. Describe for us what that is.
Sure. So there's an obscure Texas law that allows companies to split themselves into one or two or more companies and then assign assets and liabilities between them. And so what Johnson & Johnson did and what Georgia Pacific has done and three or four other companies with massive asbestos liabilities have done is they've gone ahead and created a stooge subsidiary. They on paper moved to Texas for an instant, and then they divide the company into two, and they move the bad company with all the asbestos liabilities to North Carolina, and they move the good company with all the assets and all the money back where it came and rename it itself again like nothing ever happened. And so in doing that, they can isolate the liabilities and then put the stooge into bankruptcy.
Well, let me talk about some of the key differences here. One being Purdue essentially was a single product company with OxyContin. J&J is a massive corporation with a multiplicity of products. And from a shareholder perspective, you could see a logic to containing the liabilities. And in essence, by doing that, I wonder if there's an argument that you would speed up the resolution. Is that not an argument that you think would hold water? Obviously you don't, you've moved to dismiss it, but it would seem there's an efficiency argument in favor of J&J in this case.
So that's an argument that J&J wants to make. The problem for Johnson & Johnson itself is it directly ran the talc business until 1979. And then it created a subsidiary that ran it from there forward, while J&J, the parent company, continued to maintain all of control over safety and health. And so this is wrongdoing that was done directly by Johnson & Johnson, that Johnson & Johnson is trying to wash through the bankruptcy filing of a subsidiary that has its own liability. So really, they're trying to do exactly what the Sacklers are doing in Purdue, which is their company has filed for bankruptcy, but they want to be exonerated for their individual alleged wrongdoing while keeping the majority of their money.
And capping future losses and future suits. But, I mean, one of the things that's interesting here is that we had sign-off essentially on the Purdue-Sackler deal, and it's now been paused for the Supreme Court to hear it. J&J, this has been consistently rejected. Am I correct? This particular strategy of using the bankruptcy court to contain these liabilities. So it doesn't seem like it's really working for them.
Well, the Third Circuit rejected their attempt to do this soundly when it first went up to the Third Circuit Court of Appeals, and made it very clear that the bankruptcy system is for companies that are in financial difficulty. I mean, that's sort of a duh kind of ruling from the Third Circuit, but that's what we all know. Bankruptcy is not for the super wealthy who just want a better deal. And that's what J&J wanted to do. It has complaints about the fact that the court system and juries get to decide liability. Well, that's the way our government's set up, and that's in the Constitution. And so the proper way to deal with that, if you have a complaint about it, is not to manipulate the bankruptcy system, but to go to Congress and try and get a law passed that addresses those concerns, or amend the Constitution. But all of us as Americans have rights, and if we're harmed by somebody, we have a right to a jury trial to ascertain the liability. And people that hurt other people, whether that's with opioids or asbestos products, they all complain about the inefficiency of the tort system, the inefficiency of going to court. But that's the genius of our system of government. We let citizens decide if companies have been negligent. And unfortunately for J&J, they don't like that because juries don't believe the lies that they're telling in court about their product not having asbestos.
So, Jon, you're representing a particular client whose mother died. Is that correct?
That's correct.
How many people are? I mean, last I saw was it's more than 38,000 claims against Johnson and Johnson. How are those 38,000 claimants or more likely to get a remedy? I'm assuming there's a class action, but is there a settlement for all those people that can be resolved at this point?
So there are two groups of claimants with claims, asbestos-related claims against Johnson and Johnson. There are individuals like my clients who have mesothelioma, which is a cancer of the lining of the chest or the abdomen that's only caused by asbestos. And then there's a much larger group of individuals who are suffering from ovarian or endometrial or uterine cancer that are also alleging that their cancers were caused or contributed to by asbestos-contaminated baby powder, effectively.
Yeah.
The ovarian cancer cases, if we just call them that for simplicity's sake, are mostly consolidated in the federal court in New Jersey in what's called a multi-district litigation. It has many of the same characteristics of a class action, but actually everybody has their individual claims still. And now that the case has been dismissed again, the multi-district litigation will resume, assuming that Johnson & Johnson doesn't file a third fraudulent bankruptcy.
This sounds like a case that could take decades, to fully resolve. Is that fair to say?
Well, it all depends. I mean, the reality of it is you can say, well, this would take decades if we tried each individual case to verdict. But that's not how litigation works. And Johnson & Johnson knows it. Johnson & Johnson has resolved many mass torts where their products were alleged to have harmed thousands or tens of thousands of individuals. And there's always a time where those cases are litigated and there are negotiations in the court system. And almost always they reach some sort of mass resolution. But
not through the bankruptcy courts.
Exactly.
Have they used the bankruptcy court in the past for any of these mass torts you're talking about?
Not that I'm aware of. And what's critical here is that individual claimants, people who have been harmed by these dangerous products, retain the choice as to whether they want to participate in a negotiated settlement or whether they want to go and have a trial. That's their right as an American under the 7th Amendment and under every state constitution. And what Johnson & Johnson is trying to do, and what the other companies like Georgia Pacific who have filed these fake bankruptcies are trying to do, is force claimants to accept a settlement even if they don't want to, as long as they can meet the threshold that was set up in the bankruptcy code of 75% of claimants accepting a negotiated settlement. And that's why this is so pernicious. It's so offensive to the Constitution. There's enough money in the J&J companies to pay everybody 100 cents on the dollar as determined by a jury. Johnson & Johnson admits that freely. They just don't like it. And the bankruptcy courts are for people that are bankrupt, not for people that just want a better deal.
It's interesting. Why do you think the Supreme Court is hearing the Purdue case? Why versus, J&J, this has been going on for some time. Is there a particular reason why that case you think resonates, that it would go to the highest court in the land?
Well, I think what the Sacklers are trying to do it is very difficult to accept. What they want to do, having taken billions of dollars out of the company for their own personal enrichment, and as I understand it, as reported by the courts, having placed those assets beyond the reach of the American legal system. And there's discussion of that in the various filings in the Sackler case and the Purdue Pharma case as to how the Sacklers have, and this is a generalization, how they have attempted apparently to hide their money.
Yep.
Now they want to be able to give some of that back and get basically a get out of jail free pass.
Yeah.
Without ever having to subject themselves to the scrutiny of the bankruptcy system. And if, like the court says, there's not enough money to go around in the Purdue case, even if you took every penny that the Sacklers have and every penny that Purdue Pharma has, in that situation, if the Sacklers want bankruptcy relief, they should file for bankruptcy, right? And then we can go ahead and negotiate a resolution to that bankruptcy, or have it go ahead to conclusion and have the judge rule. The difference between J&J and the Sacklers and Purdue is, I think it's pretty well acknowledged that in the case of Purdue, even if you took all the money from the Sacklers, there's not enough money to pay all the victims 100 cents on the dollar. There's just not enough to go around. For Johnson & Johnson, it's much worse because J&J affirmatively claims that it has more than enough money to pay all the victims 100 cents on the dollar. They just don't want to. They want finality. They want to remove individual choice and limit people's constitutional rights to a jury trial. And that's just wrong.
So do you think...
Come back to your question about the Supreme Court. They took the Sackler case because the Johnson & Johnson case isn't before it. It's not in a procedural posture where they would have a chance to rule. J&J had that opportunity when their first fake bankruptcy filing was dismissed by the Third Circuit as being a bad faith filing. Johnson & Johnson claimed that it was going to ask the Supreme Court to review the case, and then it backed down and just filed a second bankruptcy. And I suspect that's likely what will happen here. They'll file a third one rather than having the Third Circuit tell them that they've done something wrong again.
Well, if the decision is ruled that the bankruptcy court is not the right place to resolve these difficulties in the Purdue case, how profound a ruling will that be in terms of the analog to the case you're talking about in Georgia Pacific and other cases? Do you think that will eliminate this as a tactic for companies?
Unfortunately, what these companies have recognized, I believe, over the last 5 years, Georgia Pacific filed the first one of these manipulative bankruptcies about 5 years ago. And I think what the companies have realized is that the longer these cases are dragged out, the more they benefit, whether they eventually win or not. If the Supreme Court says that the Sacklers can't get relief through Purdue's bankruptcy, that's another nail in the coffin for this manipulation of the bankruptcy code. But will it end it? Unfortunately, when companies have billions and billions of dollars to spend on lawyers, and they're not afraid of the consequences of having their cases dismissed as being bad faith filings, we can only hope that they'll abide by the law.
So let me ask about the next steps for you. Since I saw there was recently another rejection of this tactic, if that's the right way to put it, for the Johnson & Johnson subsidiary, is this just going to keep happening of filing and refiling? Where do you get resolution for your client and for others that have claims against the company?
Well, hopefully Johnson & Johnson will abide by the ruling of the Third Circuit and the ruling of Judge Kaplan dismissing the second attempt, and they'll return to the tort system and they'll litigate these cases and resolve them, which they were doing before they filed the first fake bankruptcy. They resolved over 7,000 claims, cancer claims, before they filed the first bankruptcy over the course of less than 2 years. There's no reason why they can't efficiently and effectively manage this liability in the court system like they were doing before they filed. And I hope they'll do that. I hope they'll follow the letter of the law and the spirit of the law. I'm not optimistic because of the way it happened last time, but I'm hopeful. And on behalf of my clients, I've moved to dismiss the Georgia Pacific bankruptcy and another 2 bankruptcies that are pending in North Carolina, and hopefully we'll have some resolution on that from the Fourth Circuit Court of Appeals soon as well.
Let me ask one other question, which is more from a legal expertise point of view, which is you have expertise in terms of these sort of mass tort cases. Bankruptcy is a very different process. I would imagine it takes a different type of legal expertise to be navigating the bankruptcy system versus the tort system. Am I right about that? And I'm curious, if it's bringing in a new type of lawyer or who you work with when something is going through bankruptcy court as opposed to the usual system.
Sure, there certainly are lawyers that specialize in bankruptcy law. Amusingly, in a blast from the past kind of thing, I started my career off as a lawyer, as a creditor's rights lawyer, but 25 years ago started representing cancer victims full time. So for me, it's sort of like going home again. But there are different skill sets, but the law is the law, and justice is justice. And I believe in this system. And I think the courts more often than not get it right and get it right eventually. And I'm confident that the Supreme Court's going to see through this. There are lots of skilled lawyers, both bankruptcy lawyers and trial lawyers like myself that have been working on this. And the courts, I think, are going to get it right more often than not. And I think what that'll do is put an end to this, because the bankruptcy court isn't a menu choice for the super wealthy. There's no reason why Koch Industries should be getting relief in bankruptcy. They're not bankrupt.
Well, I certainly think those arguments will play out before the Supreme Court. Jon Ruckdeschel, thank you for joining us, and I look forward to continuing the conversation.
Thank you.